D16. Murrison, California Stores, Incorporated, v. McColgan, 30. Avoidance of taxes is not a criminal offense. The Department of the Treasury IRS Man Book, or Shuttle Agents M4112. Tax avoidance distinguisher from evasion. Any attempt to reduce, avoid, minimize, or alleviate taxes by legitimate means is permissible unless not an evasion of legal responsibility to take what advantages may accrue from the choice of any particular form of organization permitted by law. Varigance. Moot. F. Hins. Company v. Burnham, 51 R 1372 154 A 909. Never in the history of America has the need for property and asset protection been greater. It is a stark reality in today's world that a sudden financial reversal, an unanticipated lawsuit, or the stroke of a bureaucrat's pen can, overnight, wipe out a lifetime of accumulated savings and assets. Regulatory assaults on probate property are at an all-time high. Under recently passed asset forfeiture laws, the government can seize probate property for minor third-party offenses of which the property owner may not even be aware. This can create costly legal expenses and tie up time in court, even if the owner is innocent. The Pure Trust organization is a powerful tool, which can be used to protect a citizen's property from the myriad of regulatory abuses imposed by the government as well as frivolous lawsuits. Also, in today's computed and technological supercommunication age, your privacy can be invaded with the stroke of a keyboard with a citizen's social security number or federal ID hash. Personal information can easily be discovered that can fraudulently be used to abuse their credit and misappropriate their assets because the Pure Trust organization is lawfully established and bank accounts are opened in a fictitious name without a social security or federal identification number. Paper trails to the citizen are permanently severed. Most Americans do not realize that they have a choice of laws when conducting their personal and/or business affairs. Rarely do we hear about the legally recognized American common law, which is the people's laws, created by and for them. The common law existed long before statutory law and is as viable today as it was in the beginning of our country's history. Originally, the common law was created to protect the rights and the property of the people against the abuses of the sovereign king. Unfortunately, today the common law trust is seldom utilized to protect the people's property against the abuses of our current government in America. People are sovereign and may choose to legally conduct their affairs outside of government regulation. Under the common law, statutory law is a creation of the government for the purposes or regulating, fining, and penalizing the people. Although it is in the best self-interest of attorneys, CPAs, and the governmental legislatory trust, which are a creature dry and tax requiring liner for high. Is the most inhibiting for the citizen. Statutory trusts provide only limited protection for property and a truckload or paperwork, and taxes are time in prison. The statutory trust is referred to as a Rev Cable Living Trust or Grantor Trust, and is required to call 1041 form every year, whereas the common law American is law based upon and principles of justice and reason. Under the common law, as long as citizens do not infringe upon the rights of others and keep all agreements entered into knowingly, intentionally, and voluntarily, they are absolutely free to legally conduct their lives and/or businesses in any manner they choose. Under the common law, an American citizen cannot be compelled to do anything against his or her consent. The common law trust, being a creature of our constitutional right to contract, has no government regulations, no tax liability, and is not legally required to file a tax return. To put it simply, the Internal Revenue Service and other agencies of the government have no jurisdiction over common law pure trust organizations. It is American free enterprise in its purest form. Financial planning for the future. The knowledgeable and wealthy have continued to use the pure trust throughout American history. When the original 13 colonies won their independence, the man who was reputed to be the richest in the nation, William Bingham, who also served as a senator from Pennsylvania in the Second United States Congress, started a pure contract trust for his estate, which, at one time, held over 2 million acres in Maine. After 160 years of operation, the trust was terminated in 1964 upon the sale of the last of the properties involved, and because the number of beneficiaries had grown to over 300. During the trust's existence, however, it was not affected by the death of its creator or by the death of generations of trustees. It never paid a cent in probate costs or estate, death, taxes. The Kennedy family is known to maintain a number of pure trusts, a process which was begun when Joseph Kennedy created a pure trust to own the Chicago Merchandise Mart, which was valued according to a Chicago Tribune article dated March 22, 1947, at some $30 million. William Waldorf Astor, saving his heirs millions of dollars in probate costs and estate taxes, created a $50 million trust estate. It is reported that when John D. Rockefeller died, he had over 250 pure trusts. Rumor has it that the number of Rockefeller pure trusts now tops the 2,000 mark. The billion-dollar-plus Mellon family, Mellon Bank, has extensively utilized a complex structure of pure trust organizations. The Dallas Morning News carefully researched the estate of Texas oil man H.L. Hunt, who died with less than $30,000 in total personal assets, automobiles valued at $21,250 plus $5,443 in deposit in his name in the bank. Yet, he passed complete control of an estate estimated at $2 to $5 billion to his son, Bunker Hunt, without estate taxes or probate costs, through the use of pure trust organizations. Why are we not utilizing the successful history of the knowledgeable and wealthy? The leading reason people are missing out on the best in trusts is because the majority have done nothing in preparing to leave assets to their children. Most people feel that they have plenty of time and will eventually do what needs to be done. There are those who believe a good will is all they need. Their lawyer friend has convinced them that a will is the best option. There is no law that states that an estate has to go through probate, but a will mandates probate. Years ago, knowing that there was no way to stop trusts from being used, lawyers arranged the legal system to where, if you used a will, or made no provision for distribution of your estate, then the estate had to go through probate. Wills were then promoted and trusts were ignored until the last 10 years or so. Tax-free living. A family utilized a trust and transferred its assets, including house, car, and equipment used in the family business, a farm, to the trust. The family then entered into an employment contract with the trust, which required family members to live in their former house because their presence was required at all hours to manage the trust. The trust agreed to pay the family's living expenses, including lodging and food. The family took the payments tax-free because the arrangement benefited their employer, and the trust deducted its expenses. IRS ruling: the arrangement is proper even if it was adopted with the explicit intention of avoiding taxes. Source: Letter Ruling 9,134,002. Pure trust definitions. The corpus. The property held within the pure trust is called the corpus. One or more trustees manage the corpus for the benefit of an unlimited number of beneficiaries. Capital unit holders: the exchanger or settler. The pure trust is implemented after it has been signed and executed by all parties to the contract, and the exchanger, who is also called a settler, conveys property into it, creating the corpus of the trust in exchange for capital units. This constitutes a tax-free exchange. The exchanger can hold all capital units or divided them among beneficiaries of the exchanger's choice. The exchanger, settler, can be a beneficiary capital unit holder or only a capital unit holder. Beneficiaries: capital unit holders. Capital units represent 100% of the rights to the proceeds and the rights to the benefits of the property held in the trust. This is called the beneficial interest. This means that although the exchanger no longer owns the property, he retains the benefits. For example, if a car is in the trust, the beneficiary can drive the car. If a house is in the trust, he can sign a lease agreement with the trust and continue to live in the house. If a business is operating as a pure trust organization, the Benelli Siri capital holders have the right to the profits and proceeds of the business, etc. Oceeds or thalers off trust are knitted. Ers. A beneficiary capital unit. D. Introduction. Advantages of a pure trust. Knowledge is the power of the global community. For those who consider confidentiality vitally important, trusts offer privacy, protection, profit. A trust provides the first step toward total privacy. With the trust can conduct banking anywhere in the world. International banking provides the most ideal method for receiving profits, but only through a trust. What can this do for you? 1. Assets are protected 100%. The number one enemy in the world is litigation. 2. Protection from creditors. 3. Protection from liability suits. 4. Protection from malpractice suits. 5. Protection from employees. 6. Protection from personal bankruptcy. 7. Protection from excessive divorce settlements. 8. Avoids probate. 9. Avoids inheritance tax. 10. Avoids estate taxes. Pure trust organizations. 11. Avoids court actions. 12. Eliminates attorney fees. 13. Eliminates or reduces accountant fees. 14. Eliminates executors' fees. 15. Eliminates or reduces income taxes. 16. Frees tax dollars for capital appreciation. 17. Provides complete control over your assets through trustees. 18. No public record. 19. Ownership and title can be passed to heirs in complete secrecy. 20. Trust is perpetual. The trust lives on continuously. 21. Heirs cannot change, challenge, or contest any wishes at your passing on. 22. The trust is easy to maintain and very inexpensive. Principles of trust. The people perish for lack of knowledge. Hosea chapter 4 verse 6. No state shall pass any bill of attainder, ex post facto law, or law impairing the obligation of contract. The Constitution of the United States, Article 1, Section 10. The citizens of each state shall be entitled to all privileges and immunities of citizens in several states. 9. The Constitution of the United States, Article 4, Section 2, Clause 1. The properly structured pure trust organization provides the quickest and simplest legal road to freedom, creating the ultimate in tax immunity and ironclad asset protection. By transferring assets into properly structured and legally recognized pure trust organizations, you are able to maintain complete control of all the benefits of asset ownership without the inherent liabilities. Because the assets are held in trust, they cannot be liened, seized, or levied for the debts of the trustees or as beneficiaries. Further, the trustees and the beneficiaries are not liable for the debts of the pure trust. American citizens have the unlimited freedom to hold, transfer, sell, or dispose of their property in any manner. They desire. It is neither unethical nor unlawful to entail. Gently protect your family's property and your family to legally and intelligently preserve what you have worked a lifetime to obtain. Pure trust organizations have been utilized by wealthy, financially sophisticated Americans for hundreds of years. Transferring assets into a properly structured pure trust organization is as easy as transferring property to another person. Assets can be conveyed into a trust even if an erroneous notice of lien has been filed against the property. As confirmed by the Chief of Accounting of the IRS, a pure trust has no tax requirements. Therefore, there are no legal requirements for a pure trust organization to file a tax return. Since the business trust has its origin in the common law right of the parties to enter into contract, and does not spring from a franchise granted by the state, it has been held that the constitutional authority to levy excise upon commodities, income tax, a term including corporate franchises, does not empower the legislature to impose an excise privilege tax on business trusts. 266 Mass 590, 163 and 904, 63. ALR 192. The courts ruled that a pure trust is not illegal even if formed for the express purpose of reducing or avoiding taxes. 13 AM Jur 2nd 85. In Weeks v. Sibley DC 269 F. 155, Edwards v. Commissioner, 400, T. F2D 578.582 10th Seer, 1969, and Phillips v. Blatchford, 187 Mass. 510.
Your lawyer's secret oath? What was the effect and the significance of the Erie v. Tompkins case decision of 1938? The significance is that since the Erie decision, no cases are allowed to be cited that are prior to 1939. There can be no mixing of the old law with the new law. The lawyers, who are members of the American Bar Association, were and are currently under and controlled by the Lawyers Guild of Great Britain, created, formed, and implemented the new bankruptcy law. The American Bar Association is a franchise of the Lawyers Guild of Great Britain. Since the Erie v. Tompkins case was decided, the practice of law in this country was never again to be the same. It has been reported, source unknown to writer, that every lawyer in existence and every lawyer coming up has to take a secret oath to support the bankruptcy. This seems to make sense after you read about Mr. Sweet's case file disappearance discussed later in this report. There is more to it. Not only do they promise to support the bankruptcy, but the lawyers and judges also promise never to reveal who the true creditor party is in the bankruptcy proceedings. In court, there is never identification and appearance of the true character and principle of the proceedings. This is where you can get them for not making an appearance in court. If there is no appearance of the true party to the action, then there is no way the defendant is able to know the true nature and the cause of the action. You are never told the true nature and the cause of why you are in front of their court. The court is forbidden to tell you that information. That's why, if you question the true nature and cause, the judge will say, "It's not my job to tell you. You are not retaining me as an attorney and I can't give you legal advice from the bench. I suggest you hire a lawyer." The problem here is, if you hire a lawyer, who is pledged not to reveal the true nature and the cause, how will you ever find out the nature and the cause? You won't? Why? If the true nature and cause of the action against you is revealed, it will expose the real creditor from whom this action and cause came. In other words, they will have to name the true creditor. The true creditor will have to state the nature and the cause. The true creditor will have to say, "It's a bankruptcy proceeding." The true creditor would have to say, "I'm the creditor and he's the debtor." That declaration then opens the door for you to question, "Who the hell are you? How did you get attached to my back and by what vehicle did I promise to become a debtor to you?" In this country, the courts on every level from the justice of the peace level all the way up, even into the international law arena, called the World Court, are administrating the bankruptcy and are pledged not to reveal who the true creditors really are and how you personally became pledged as a party or participant to the corporate United States debt. What would really kill these people off would be to compel the international bankers to send a lawyer to the courtroom and present himself as the attorney for the true creditor, the international banksters, then have the attorney to put into the record the true nature and the cause of the proceedings against you on that particular day. The international banksters told these various countries that they were now in a state of bankruptcy. The countries had been taken over by the creditor bankers, and there was no choice but for all these participating countries to declare bankruptcy. If they didn't agree to declare bankruptcy, the banksters threatened to collapse the economies and thereby put the countries back into the depression like the one from which they were just emerging. The banksters made an offer they couldn't refuse. To review and elaborate, in 1930 there was a worldwide depression. The bankers said, "Look, you can do it either of two ways, the easy way or the hard way. You just accept the bankruptcy and we'll let you out of the depression. If you don't, you're on your own." So all the countries involved agreed, because they realized that the international banksters had them by the throat. The countries therefore agreed that over a period of several years they would pass statutes and legislation for the implantation of the bankruptcy in favor of the international banksters. Now, I would say that the key banksters were Rothschild and family and their agents by way of Rockefeller, by way of the Federal Reserve banksters, who were more specifically involved as key banksters and their agents, is pure conjure on my part, but it really doesn't matter at this point. The point is, there was an international bankruptcy and an international conspiracy to cover it up. There was a banking creditor who made the offer. The countries accepted the offer in order to enable the representative countries to continue without revolution and to allow the politicians to remain comfortably in place. Under a delusion of solvency, the countries were allowed to continue to operate as though they were solvent, while in fact, the representative countries were bankrupt. The snare the bankruptcy scheme was is an extremely clever and diabolical plan. How did they possibly pull this scheme off in the area of real estate? The bankers did it with real estate, the same way they did it in the area of federal income taxes. These foreign banksters simply and deceptively devised ways and means to con you into declaring yourself as a citizen or a resident of the corporate U.S. Remember, the corporate United States is bankrupt per agreement and public policy. After you have been tricked into claiming you are one of their corporate United States citizens, you are given a social security number which ties you to certain meager benefits and privileges. Then, the banksters con your employer to function as an unpaid tax collector to con you into filling out their W-4 intangible property gift forms and 1,840 voluntary agreements. These slick paper agreements establish your voluntary indebtedness to the bankster creditor. If at any time you decide to balk at this scheme, because you don't like it, the real creditor never has to make an appearance in court to list the true nature and cause of the actions which is being brought against you. You end up dealing with an agency. The agency can conveniently grant itself immunity from prosecution because all it is doing, without your knowledge, of course, is administrating the bankruptcy, which the government agreed per the Geneva meetings. The court system never lets you put the original creditor on the courtroom stand, so you can ask him how he got attached to your back. The system is set up in such a way that the true creditor is protected and never has to make an appearance and never has to answer any of your questions or produce documents. Therefore, the true creditor never has to produce the law that gives him the right to pledge you, your body and labor, into indebtedness bandage servitude. Why? Because the Geneva Agreement in 1930 was done by treaty. The bankruptcy was not done by legislation. The agreement came first, signed in secrecy. Then Congress began to pass legislation to fulfill the bankruptcy obligation required by the treaty. Legislation being passed by Congress was henceforth and is thereby bankruptcy legislation. When cases came before the courts could make decisions based on the new controlling law of bankruptcy. It had nothing to do with constitutional rights. Now, any case brought in is under the new bankruptcy law and is not considered as a true constitutional case. It is now a bankruptcy case as distinct from, but cleverly disguised as a constitutional case. The members of the Supreme Court, of course, realized what was happening to them in the system of law. The court was being asked to perform in a creditor-debtor bankrupt proceeding to the benefit of the bankster creditors. The members of the Supreme Court said, "No, we will not give you a bankrupt proceeding decision that you can then enforce against everybody. A decision not only affecting corporate Washington, D.C. but also having effect within the corporate state governments. This, by the way, is fraud. It wouldn't be fraud if the government of corporate Washington, D.C. and the government of the several corporate states declared bankruptcy, then let the people know about the bankruptcy notice. When I say corporate government, I don't mean you and me. You and I are not the corporate government. The corporate government is the corporate capital of the corporate state. The government is a neutral government zone known as the corporate capital of the corporate state. The government is where the corporate state is. It is corporate headquarters. Just like corporate Washington, D.C. is the seat of the corporate federal government, the capital of the corporate state is the seat of the corporate state government. If the recent case, he won his case. He went into court and defended his common law lien on his property so as to be compatible with statutory law. The judge said, "However, since you presented me with a lien on your property, I will stipulate that the county is the owner of your property with the provision that all liens be satisfied." Sweet was very happy about the judgment. Sweet doesn't care if the county is the owner of the property because the county can't take the property for the next 90 years. The county can't take the property away from him because of his common law lien on the property. Sweet is free to use it, rent it, whatever. If the county really wants the property, they have to satisfy the lien first. However, there is a problem regarding setting a precedent. Sweet went back a couple of weeks later and asked them to punch up his case number. Guess what? The case number had disappeared. The reason the case number disappeared is that after the judge ruled the county owned the property, subject to the lien, it became a case that goes against the corporate county bankruptcy public policy. Since Sweet placed a lien on his own property, he is the one who has to be paid off first, not the county. The county is now required to satisfy the lien before the county is allowed to take possession of the property. The property is probably not worth the price of the lien. This would not satisfy the true creditors, the international banksters. If the county pays Sweet off first, the city has to put on their records a $75,000 deficit. The true creditors wouldn't like that deficit. They certainly wouldn't like the fact that Sweet's clever maneuver had outfoxed the foxes. What if 100, 200, 1,000, or 10,000 people in your state would just put a common law lien on their property and then stop paying taxes? Then cited Sweet's case, it would set a precedent. Let the county have the property as long as the judge makes the judgment subject to existing liens. In this situation, the county would end up holding all this property but could have no use of it. No rent, no taxes, no permits, all deficient. The bankster creditors certainly don't like this scenario. The banksters don't want any cases administered except through the application of bankruptcy procedure. The banksters want your rights, privileges, and due process strictly administered by and through the corporate courts under their corporate public policy. International bankruptcy procedure. The international banksters and their unregistered foreign agents don't want any evidence on the record, showing how you can get out from under them. Any revenue collecting individual or agency such as the courts, judges, lawyers, law enforcement officers, and tax collectors who are attempting to take money from you as a private American must be registered as a foreign agent. If they are not duly registered and properly identified, they are involved in extortion treason against private Americans. How Sweet it is. As part of Sweet's maneuver, he filled out a financing statement using the UCC-1 form, whereby he put his wife and himself as debtors and creditors. Now, the legal situation is switched. The UCC-1 financing record Sweet filed with the state shows Sweet and his wife as being the parties of interest recorded with the state rather than the presumption that the international banksters are the parties of interest. There is an office within each corporate state, Secretary of State, that handles the Uniform Commercial Code UCC-1 claim forms. Since Sweet is listed on corporate state records as debtor and the creditor on his own property, his property can't be put up in any way for collateral against any debts claimed by the banksters. The reason is that the international banksters and their flunky agents now cannot prove that Sweet's property is debt property of the bank or the corporate county. The property cannot be put up against any debt claims until it is not encumbered by Sweet's lien. Sweet's property is not free and clear of all liens. The result is that for all practical purposes, the property is now Sweet's, being unencumbered by any further demand for payment of taxes. Sweet has not paid property taxes for many years. Sweet is now his own creditor, and Sweet is his own debtor. Therefore, the international banksters along with the county corporate thieves are knocked out of the stealing process. How sweet it is. Congratulations to Mr. Sweet. You may want to do it the way Sweet did. If you own property, you will need to get your deed and a common law lien, then fill out a UCC-1 form, then file it with the Secretary of State. This seems to be the only way for you to get out from under being a debtor of these bastardly corporate foreign international banksters. The judges have to know what's going on. The only way this scheme can work is to have all the lawyers and judges pledge to uphold the corporate bankruptcy public policy. The banksters just can't allow lawyers in a legal system who refuse to uphold the bankster policy. These renegade lawyers would have to be quickly weeded out. They certainly have a neat little system going here in America, the land of the free and the home of the slave. Attention, law student, you said you wanted to be a lawyer. Well, I hope you're reading carefully, because here is the legal system you're headed to serve, and serve you will. You said you wanted to be a lawyer so you can find out what oath they're taking, in secret, behind closed doors in solemn preparation for the business of the court as judges and lawyers. Now, you know the oath. The oath is simply to uphold the bankruptcy. If you want to be a lawyer and want to make a living as a lawyer, I can tell you this. They will weed you out at the very beginning if you don't bring in your paperwork under the bankruptcy procedures. If you try to defend your clients and try to help your clients, they will get rid of you. They will pull your license. So you spent all that money and time going to school under the disguise of helping people, and you're wasting your time. Without that license you can't go into a courtroom. I would think about this. Traffic citation regarding the UCC1 form. You can also file it against your car. Wouldn't that be a kick in the tail if you went into court for a traffic citation where you had signed without prejudice UCC 207, and you had dishonored the traffic citation using the UCC in your procedure by having signed without prejudice and having gone home and sent in your dishonor of the presentment of the traffic citation. Now, let's say you are in front of the judge. The judge says, "What's this dishonor stuff all about?" The judge will not want any mention that the citation was issued under bankruptcy. He is afraid you'll mention the bankruptcy issue. The reason you dishonored the traffic citation is that it was issued to you under bankruptcy corporate public policy. He won't get into that. When you get before the judge, you just state you have removed yourself from the bankruptcy. Tell him your auto is no longer pledged for collateral against the debt. He'll say, "Oh yeah, what are you talking about?" That's when you hand him the UCC1 form that you filed with the state. This UCC1 form will show that you are the debtor and the creditor on your auto. Now what happens? The corporate county state can't collect on the traffic citation debt instrument. Why? Because, not that you're the creditor on the ticket. If they collect a $100 fine, they have to pay you the amount of the fine. How sweet it is. You're the creditor, aren't you? People have done this. Of course, there is no record, no paper trail. In such cases it is not cited. The corporate banksters' agents, clerks, lawyers, judges etc. take the information out of the records as soon as you beat them at their own game. Here is what I think happens in these cases. The American Bar Association is a franchise of the Lawyers Guild of Great Britain. The American Bar Association is not concerned primarily with what happens in any case on the local level. However, when a case leaves the local level, by that, I mean the state court, city court or the justice of the peace, or even the federal court, and goes to the appeals court, it would appear that the American Bar Association takes notice of the case. It would seem that the American Bar Association must have an agreement that any action brought on an appeal must be reviewed by the American Bar Association. If this is true, it would make sense. How else would the American Bar Association, a branch of the Lawyers Guild of Great Britain, which is the legal arm of the Rothschilds dynasty, be able to monitor and administrate the corporate bankruptcy? It would appear that the American Bar Association would be compelled to review all appeal cases and to make certain any case brought under common law or the constitutional law that would expose the bankruptcy would be immediately stamped on the back that this case is not to be cited or published. I believe that this is the stamp origin and purpose of the stamp message in such cases. The Justice Department may be able to do that in Washington, D.C. I can't see where any judge or lawyer could have the authority to stamp or label the case as one not to be cited for future cases. I think that is an official stamp from the American Bar Association. The bankruptcy accounting system now. Joe, law student, if you're still attending classes and you have a good professor, ask him her about just where the stamp comes from that you've seen on many cases. Just who put it on the paperwork and just who authorized the citation restriction. Just who is tampering with the law. There is one thing certain. The creditor and or his agents are watching these cases very carefully. The creditor and his agents must balance their books. When you think of the IRS, be aware that the IRS is an agent of the creditor, the corporate international banksters. This is just one of the banksters' stateside agencies. The General Accounting Office, GAO, is another agency they use for this country. This is where all the accounting goes to keep track of